Hello?
Hello? Right. Got mission to do.
The issue is whether the state of Switzerland can become a party to the Convention Against Torture even if Switzerland wishes to employ reservation that allows torture of terrorist suspects, despite the objection by the state of Pastaland.
According to Sir Robert Jennings and Sir Otto Watts in Oppenheim's international law refers to a body of rule that is illegally binding to states in their intercourse with each other. International law, according to Article 38, subsection 1, para A of the Statute of International Court of Justice, is international convention, whether general or particular, which establish rules recognized by the contesting state. Convention is also known by other names such as treaty, concord, or pact. Law of treaties can be defined as a body of rules providing treaties, definition, and deals with matters relating to conclusion, entry into force, application, validity, modification, amendment, interpretation, suspension, and termination of treaty. In international law, it plays a role similar to contract law. Article 2, subsection 1, para A of Vienna Convention defines treaty as an international agreement concluded between states in written form and governed by international law, whether embodied in one instrument or in two or more related instruments, and whatever its particular designation.
Consent to a treaty may be by way of expression, by signature, ratification, or accession, and is binding on the party to it, who shall carry out the treaty in good faith in accordance with the maxim pacta sunt servanda, which means agreements must be kept. This may be applied to all types of treaty, whether multilateral, bilateral, universal, or regional.
Moving on to the principle of law of treaties. There are several principles of law of treaties. For instance, the principle of free consent that implies a state may not be bound to a treaty in which they do not give consent to. However, exception to this general rule is that it may be binding to non-parties if it becomes part of the customary international law. Furthermore, by virtue of Article 26 of Vienna Convention of the Law of Treaties 1969 stipulates that every treaty in force is binding upon the parties to it, and it shall be performed in a good faith. This emphasizes a close ties between maxim, pacta sunt servanda, and good faith principle. The ICJ, International Court of Justice, in Hungary against Slovakia stipulates that Article 26 consists of two important elements, that is, maxim pacta sunt servanda and good faith principles. This, as a result, if a party breaches the maxim pacta sunt servanda, then it also breaches the good faith principle. As opposed to maxim pacta sunt servanda that applies to all treaties which are in force, the principles of good faith is all-encompassing, as it even obligates the state even in the pre-ratification stage. Article 18 of the VCLT, for example, mandates a state to refrain from doing any acts that could defeat the object and purpose of the treaty in a situation where they had signed but not yet ratified the treaty, or they had ratified but the treaty has not yet entered into force.
How does a state express consent to be bound?
Firstly, by signature, that serve as authentications of agreed treaty and creates an obligations of good faith. However, if the treaty states that the signature is subject to ratification, acceptance, or approval, the signature does not equal consent to be bound. But the signature still qualifies the signatory state to proceed to the next stage, such as ratification. Secondly, by ratification, that consists of two-stage process of first, giving the signature subject to ratification, and second, submitting an instruments of ratification. Moving on to the third one, by accession, where state did not participate in the initial drafting process, become parties, but at a later stage. For states that participate from the beginning of the treaty creation, they will enjoy wide discretion in deciding when and by what means it will come into effect. They have flexibility to determine the means of which the treaty enters into force, as stated under Article 24, Subsection 1 of VCLT.
Sometimes the state can also employ reservation in the course of giving the consent to be bound by a treaty. Article 2, Subsection 1 Para D of Vienna Convention explains reservation as a multilateral statement, however phrased or named, made by a state when signing, ratifying, accepting, approving, or acceding to a treaty, whereby it purports to modify or exclude the legal effect of certain provision in the treaty in their application that state. This is a mechanism for a state to alter the terms of a treaty whose text has already been adopted according to its own will. Usually, reservation is employed in multilateral treaties but sometimes also in bilateral treaties. And according to Article 19 of BCLT, states may formulate reservation when signing, ratifying, accepting, approving, or acceding to a treaty, but there are 3 exceptions and limitations.
However, Article 19A shows where reservation is prohibited. For example, Supplementary Convention on the Abolition of Slavery, whereby Article 9 of this treaty prohibit reservation. Then, Article 19B, where it states that only the specified reservation that do not include reservation in question may be made. Or Article 19C, where it states that in a situation where the reservation falls outside the previous paragraph, the reservation is incompatible with the treaty objects and purpose. Regarding the acceptance of an objection to the reservation, Article 20 provides several examples. Firstly, paragraph 1 says that reservation that is expressly authorized by a treaty does not need consent from contracting states. Secondly, paragraph 2 says that if it appears the purpose and objective of the reservation in its entirety, the application between all the parties of consent to be bound is an essential condition, then the reservation must gain acceptance from all the parties. Also, paragraph 3 says that when a treaty is a constituent instrument of an international organization, unless provided otherwise, it must obtain acceptance from the competent organ of the organization.
According to paragraph 4B of VCLT, which states an objection by another contracting state to a reservation does not preclude the entry into force of the treaty as between the objecting and reserving state unless a contrary intention is definitely expressed by the objecting state. This means that when one state, i.e. the objecting state, objects to a reservation made by another state, i.e. the reserving state, concerning a treaty, it does not automatically prevent the treaty from becoming effective between these two states. The treaty can still come into effect and be binding between the objecting state and the reserving state despite the objection. However, if the objecting state explicitly and clearly state that it does not want the treaty to enter into force between itself and the reserving state, then the treaty will not come into effect between them. Moving on to the paragraph 5, which also states that for purposes of para 2 and 4, unless provided otherwise, a reservation is considered accepted if the state raises no objection by the end of a period of 12 months after it was notified of the reservation or by the date at which it expressed consent to be bound, whichever is later. Article 21 paragraph 3 also stipulates that when an objecting state to a reservation does not oppose the entry into force of the treaty between itself and the reserving state, then the treaty applies between them without the reserve provisions to which the treaty relates. Example of reservation can be seen in Belarus and Switzerland case where the applicant Belarus claimed that her trial before Laos in police board was in violations of provision in Article 6 of European Convention of Protections of Human Rights and Fundamental Freedoms that stipulates everyone is entitled to hearing by independent and impartial tribunal. Switzerland argued that they already employed reservations. The European Court of Human Rights applied the reservation definition under Article 2 Para 1D of the Vienna Convention and decided that it was indeed a reservation.
Reservation is particularly problematic when states employ it towards human rights treaties. Referring to Part 1, Paragraph 26 of Vienna Declaration and Programme of Action (VDPA), that was approved by the UN General Assembly, it emphasizes that all states are encouraged to accede to the international human rights instrument, but states are encouraged to avoid the resort to reservation as far as possible.
The problem lies decides on firstly whether to accept the ICJ position in reservation to the Convention on the Prevention and Punishment of the Crime of Genocide advisory opinion that stated if a reservation is compatible with object and purpose of convention, the reserving state cannot be party to the convention. And then secondly, reservation is not appropriate for human rights treaties that seek to guarantee minimum standard of basic rights for individuals because allowing it will reduce the standard of human rights protection, which is very low already due to the multilateral nature of these treaties. Thirdly, it is inappropriate to apply reciprocity rules because human rights treaties are concluded to benefit individuals, not contracting states. Lastly, Article 19 of Vienna Convention on the Law of Treaty 1969 (VCLT) provides that states may formulate a reservation when signing the treaty but not after the treaty came into force.
In the given situation, the state of Switzerland only wishes to become a party to a convention against torture, and they are not yet bound by the treaty. Hence, they can create a reservation in the treaty which would allow the torture of terrorist suspects. However, according to Article 19C, the reservation which is incompatible with the purpose and object of the treaty is prohibited. In the given situation, the state of Switzerland wanted to create a reservation in which it would allow them to torture terrorist suspects, although the treaty prohibited such act. In addition, as it is only a suspect following the principle of everybody is innocent until proven guilty, it is wrong to punish them. Following paragraph 3 of Article 20, the state of Switzerland must first obtain approval from the relevant organization, that is, the World Organization Against Torture. After gaining the approval from this organization, only then they could proceed to employ the reservation.
Paragraph 4b stated that an objection made by another state does not preclude the entry into force of the treaty by reserving state. In the given situation, even if Pastaland rejected the reservation, Switzerland can still become a party to the convention. Next, applying Article 20, Para 5 of VCLT, the state of Pastaland is aware that Switzerland is going to issue a reservation, but they are against it. However, it was not explicitly stated that Pastaland had raised any objection against the issuance of the reservation. Therefore, the reservation can still be valid.
Article 21, paragraph 3 stated that when a state objects the reservation but does not oppose the treaty, the reservation does not apply to the objecting state. Therefore, if the reservation issued by Switzerland does not lie under the exception, Pastaland is not bound by the reservation because they are against it.
In conclusion, if the reservation issued by Switzerland is allowed, although it is opposed by Pastaland, Switzerland can still become a party to the convention by virtue of Article 20, Para 4b of Vienna Conventions of the Law of Treaty 1969.